tone a little bit and come to a kind of a relevant hot topic which is in news recently, and we'll have some fun, engage up some momentum and energy of the class to discuss one of these issues. So now brace yourself for a very, very fascinating event developing in the current affairs as we speak, sure to be a very favorite for the UPSC for creating an exam out of it. Let's take a look at what is known as the disqualifications of MPs under the Constitution. I'm going to categorically and step by step make a case about what it means to have this entire chapter covered. Every little bit of piece of information that you would need for the prelims examination will be covered under this header. Okay, disqualifications of MPs under the Constitution. Okay, let me just give a brief understanding of what is happening over here. Parliament of India is governed by Articles 79 to 123 of the Constitution. Okay, Article 79 to 123 of the Constitution is where you have the articles with reference to the Union Parliament. Okay, it provides for the two houses which is the Lok Sabha and the Rajya Sabha. That is also known, the Indian system of having two houses is also known as a bicameral legislature. Bicamera means two chambered or dual chambered, bi means two, camera means chamber. Okay? Then of course we have the conditions on which you have qualifications for being an MP. Okay, so what are qualifications given in the Constitution? For the Lok Sabha, you have to be a minimum of 25 years, and for the Rajya Sabha, you have to be a minimum of 30 years. This is the first qualification given in the Constitution. Plus, you have to be a citizen of India. These are two qualifications which are given for a person to become a member of Parliament in the Constitution of India. Okay, and in addition to this, if there are any other qualifications which are required, it will be given in the Representation of People Act 1951. Right, so a simple question as to what law made by the Parliament governs the qualification and disqualification of Member of Parliament? The answer to that is Representation of People Act 1951. Two conditions, however, are given in the Constitution directly. 25 years is going to be the minimum age for the Lok Sabha MP, and 30 years is going to be the minimum age for the what you can call the Rajya Sabha MP. Over and above that, the conditions for qualifications are given in the Representation of People's Act. Okay. Now let's take a look at a bit of a understanding of what is happening over here. Article 102 of the Constitution, let me just give you a clear understanding of it. Article 101 of the Constitution deals with vacation of seats at the Lok Sabha and Rajya Sabha. Okay, it says in what manner can seats be vacated from the Lok Sabha and the Rajya Sabha. किस तरह से लोक सभा और राज्य सभा से सीट्स को खाली किया जा सकता है. That's the point that the Article 101 of the Constitution makes. I'll just put out the grounds of vacation. ठीक है, what are the grounds which are given in? आप इनको copy कर सकते हैं, directly MCQ की तरह आ सकता है. Grounds. First ground which is given for vacation of seats in the Lok Sabha and the Rajya Sabha is what is known as if a person is a member of both the Lok Sabha and Rajya Sabha simultaneously. मतलब अगर कोई एक व्यक्ति दोनों ही सदन का मेंबर्स है, लोकसभा और राज्यसभा का, एक ही समय में, तो उसको डिस्क्वालीफाई किया जा सकता है अनलेस ही रिजाइंस फ्रॉम वन ऑफ द मेंबर्स. ओके, मेंबर्स ऑफ बोथ द यूनियन पार्लियामेंट एंड स्टेट लेजिस्लेचर. अगर कोई व्यक्ति यूनियन पार्लियामेंट और स्टेट लेजिस्लेचर का साइमल्टेनियसली मेंबर है, if a person is a member of the union parliament and the state legislature at the same time, he can be disqualified from both the houses unless he is गिविंग रेजिग्नेशन फ्रॉम वन थिंग. ठीक है, तो ये दो ग्राउंड्स हैं वेकेशन के कि अगर बोथ लोकसभा और राज्यसभा का व्यक्ति है तो उसको वेकेट करनी पड़ेगी अपनी सीट, और राज्यसभा और यूनियन पार्लियामेंट और स्टेट लेजिस्लेचर का व्यक्ति है तो उसको एक जगह अपनी सीट वेकेट करनी पड़ेगी. राइट, दिस इज द ग्राउंड्स फॉर वेकेशन. तीसरा जो ग्राउंड है वेकेशन का, दैट इज डिस्क्वालिफिकेशन. ओके, दैट इफ अ पर्सन इज डिस्क्वालिफाइड अंडर Article 102 and the Representation of People Act 1951. These are the two statutes which deal with disqualification. Okay, if a person is disqualified from a membership of the Lok Sabha and the Rajya Sabha under Article 102 and the Representation of People's Act 1951. This is what I am going to deal with the case of the Member of Parliament with Wayanad, who's been disqualified by the Lok Sabha Secretariat recently. Okay, and the fourth ground for vacation is by resignation. That a Member of Parliament can resign from his seat. Okay, but the resignation can be rejected by the speaker / chairman. Okay, so the very simple MCQ kind of a question which can come this time. What are the grounds on which Lok Sabha can be, or Lok Sabha and the Rajya Sabha seats can be vacated? The Lok Sabha and Rajya Sabha simultaneously, if a person is member, he has to vacate one of the seats. If he is a member of the Union Parliament and the State Legislature, he will have to vacate one of the seats. C, disqualification under Article 102 of the Constitution and and the Representation of People Act 1951, which talk about the grounds of disqualification and resignation, but can be rejected by the Speaker and Chairman. This is a simple setup of how MCQ can be drawn. Right now, I want to take up this particular part, which is regarding disqualification. And I want to stretch it out. Okay, starting with the next point over here. Article 102 of the Constitution, in succession to Article 101, talks about grounds for disqualification. Again, I am putting it in a very MCQ format for the reason that disqualification of an MP is all over the news recently. And if you have any care about your prelims examination, you will listen to everything that is being talked about over here, because it is going to be a very, very probable question. Disqualification of an MP is all in the news. Okay, so Article 102 takes out grounds for disqualification. I'm putting it in an MCQ format again. The grounds of disqualification mentioned under Article 102 are: A, a person is holding an office of profit. Okay, disqualification of an MP, Member of Parliament of Lok Sabha and Rajya Sabha, if a person holds an office of profit. Okay, B, if a person is of unsound mind. Okay, C, if a person is an undischarged insolvent. The person who has been declared a Diwaliya. Please take note of these. If you want to memorize them, do it now. D, if a person is not a citizen of India. Or has given up the citizenship of India to acquire the citizenship of a foreign state. And E, E says, under section 8 of the Representation of People Act 1951. Under section 8 of the Representation of People Act 1951. Please take note of these things. Okay, if you have a question about what are the grounds of disqualifications given in the constitution of a member of parliament, I have set it out in a very perfectly styled MCQ format. Okay, a grounds for disqualification of an MP: A, office of profit; B, unsound mind; C, undischarged insolvent; D, not a citizen of India; and E, under section 8 of the Representation of a People's Act. Okay, UPSC Gyan is asking the question, if office of profit is not a ground for vacation, let's go to it again. Disqualification is a ground for vacation, and a person will be disqualified if he is holding an office of profit. So by default, a person who's holding an office of profit who will be disqualified will eventually have to vacate. Vacation means someone is moved, someone is leaving his chair. Vacation by the means of disqualification means someone is leaving his chair that he's been asked to leave. He is not eligible to sit on the chair anymore. So C is a ground for disqualification. Okay, and C is what you can call a ground for vacation, or what you can call a example of vacation, and office of profit is an example of disqualification. So if you put a syllogism over here, you have office of profit under disqualification and disqualification under vacation. Therefore, you are correct. Holding an office of profit is a kind of a vacation, but not directly, mediatively. Okay. So grounds for disqualification of an MP, this is what we have taken a look at. So now I want to elaborate upon the section 8 of the Representation of People's Act as to what it is basically trying to say. But before that, let me take a look at, and we can go to the section 8 of the Representation of People's Act. We are coming close to what is the current case over here. Now, the Indian Penal Code, again please be aware about the information that I am laying out on the board. 1860 is a code which gives punishment for offences. Okay, it's what you can call, Indian Penal Code is a criminal law. Right? It is a criminal law, and the what you can call the objective of the Indian Penal Code is to fold. Let's say first is to convict a person of committing an offence. That you have to determine, for example, that X has committed murder. By conviction, one means that the judge is convinced. See, conviction in English language means convinced, that you have completely arrived at the conclusion that it is X who has committed murder. Right? So this is the first thing that is decided in the Indian Penal Code. And then the second thing that is decided in the Indian Penal Code, that according to the circumstance of the case, the judge sentences the person for committing an offence. Now see, all this is going to be important for the prelims examination. Only last year there was a question in the prelims examination with regard to the difference between judicial custody and parole, judicial custody and arrest. Okay, which means that the UPSC is going beyond the mandate of only asking questions from polity, but it is also venturing out in law and Indian Penal Code, etc., etc. That's why I'm trying to indicate this to you. Conviction of a person is that a judge is satisfied that a person has committed the crime. Sentence of a person means that what kind of punishment does judge want to give to the person. Let's say, for example, if a person is found guilty of having committed a murder, it's a conviction of murder that he is guilty of committing the murder. But let's say if he has committed murder under some kind of a force, some kind of a pressure, some kind of a social distress, then that kind of a factoring in would be taken into account before punishing him for the conviction of murder. And let's say if he is living under a lot of social distress or economic distress, then you can take a look at, for example, what is known as the sentence of a person for committing an offence is basically reduced if he is under emotional and social distress. But if the person is completely fine and he is not under any emotional distress, then the sentence would be higher. So sentence means to give him punishment. Conviction means to be convinced that he has committed the crime. You can convince yourself that he's committed the crime, but nonetheless his sentence may vary according to the conditions under which he has committed the crime. Higher sentence for not unreasonable conditions, and lower sentence for unreasonable conditions, right? That kind of a thing is given as what you could call a conviction and a sentence. Now, I want to take a look at what is known as section 499 of the Indian Penal Code. Section 499 of the Indian Penal Code and Section 500 of the Indian Penal Code. Section 499 is the definition of what is known as defamation, manhani as it is called. Okay. Section 499 of IPC is the definition of defamation. Okay, this is how defamation is defined under Section 499. And Section 500 of the Indian Penal Code gives the punishment for defamation. Again, this is going to be important because the case that we are dealing with in terms of disqualification of member of parliament is with regard to defamation only, right? So what is the punishment for defamation is a question that we can ask ourselves. Ashutosh, you're absolutely correct. The 10th schedule is a ground for disqualification. I wanted to write it later on because I was trying to deal with anti-defection all of its own. But yes, if you say, we can put it over here. Article 102, Clause 2, 10th schedule, or what is known as the anti-defection law. 10th schedule, or what is known as the anti-defection law, is a ground, or what you can call ground or fifth ground for disqualification. We'll read the 10th schedule in elaboration in a bit because of the recent upheaval which has been happening in the Maharashtra Legislative Assembly because of the governments changing from one port to the other. Okay, so we'll come to that 100%. But okay, because we wanted to write it right now, we can do it. Article 102, Clause 2. The punishment which has been given for defamation under the Indian Penal Code is as follows. Okay, the maximum punishment that a person who is convicted of committing defamation can be punished to the maximum of 2 years of imprisonment. Plus fine. Okay, let's say this is the harshest punishment, point number A. Second harshest punishment would be, let's say, 2 years of imprisonment without the fine. Okay. Third harshest could be, let's say, reduce the term of the punishment. 1 year punishment plus fine. Okay. Then let's say, for example, no punishment. No imprisonment. I don't mean to say punishment, I mean to say imprisonment. no imprisonment, only fine. Okay. And the most lenient of this thing, most lenient would be no imprisonment plus no fine. So this is the range in which defamation can be punished under section 500 of IPC. The least is no imprisonment plus no fine. Then fourth is only fine. Then third is 1 year imprisonment plus fine. Second is 2 years of imprisonment minus fine. And maximum punishment is 2 years of imprisonment plus fine. If you are convicted of criminal defamation under section 499 of the Indian Penal Code, then the maximum that you can be punished for is 2 years of imprisonment and some fine. Okay. And the second worst that could happen to you is that your fine can be relaxed, but your imprisonment is taken to the maximum period of 2 years. Okay. Let me, for example, let's say open up the copy of the Indian Penal Code to make you read a little bit about the criminal defamation part, because I think this is going to be an important chapter in the mains examination this time, because of what is happening in the current affairs. Okay, take a look at this. Just a simple definition that you can read of defamation over here to get a simple sense of what defamation means. Defamation, as defined under the Indian Penal Code, is that if any person by words either spoken or intended to be read, मतलब अगर कोई व्यक्ति कुछ बोल के या फिर कुछ ऐसे शब्द जो लिखता है जिससे कोई पढ़ सके, या फिर by signs or by visible representations makes or publishes any imputation concerning any person intending to harm or knowing to having reasons to believe that such imputation will harm the reputation of such a person is set to defame that person. इसका कहने का सिंपल मतलब ये है इस परिभाषा का कि अगर कोई व्यक्ति मौखिक शब्दों से, लिखित शब्दों से या विजिबल रिप्रेजेंटेशन और साइन लैंग्वेज से किसी व्यक्ति की रेपुटेशन को हार्म करता है, तो उसको कहा जाएगा कि उसने दूसरे व्यक्ति को डिफेम किया, उस व्यक्ति की मानहानि करी। ये सिंपल सी परिभाषा है डेफेमेशन की सेक्शन 499 के अंदर। उसके नीचे काफ़ी सारे ऐसे एक्सेप्शंस दे रखे हैं जहां पर कोई एक्टिविटी होगी तो उसको डेफेमेशन नहीं कहा जाएगा। जैसे फॉर एग्जांपल, अगर मान लीजिए कि किसी व्यक्ति ने किसी पब्लिक अथॉरिटी के बारे में कोई सच्ची बात बोली जो कि समाज के लिए जानना ज़रूरी था, तो उसको डेफेमेशन की डेफिनेशन में इंक्लूड नहीं करेंगे। व्हाट आई एम ट्राइंग टू से इज दैट द सेक्शन ऑफ द IPC 499, it defines defamation, but then after that it lays out certain things or certain ideas which cannot be held as defamation. They are exceptions to defamation, but nonetheless you are not concerned about the exceptions, you are only concerned with the rule. And then we come to section 500 of the Indian Penal Code, which states that the punishment for defamation is a maximum term of 2 years of simple imprisonment with fine. This is the maximum amount of punishment that can be given to a person of defamation. ठीक है, चलिए अब हम क्या करते हैं, अपने करंट अफेयर्स के पॉइंट पे आ जाते हैं. Our story starts at a point where a member of parliament from Kerala in the 2019 elections, the campaigning for the 2019 elections, was found to be saying certain things about a particular group or a caste or a community. Okay, and in 2019 a FIR was registered against the person, charging section 499 and 500 under the IPC in Surat, and the matter was taken up by Judicial Magistrate First Class. The matter was taken up by Judicial Magistrate First Class of Surat in 2019. But nonetheless, the matter did not proceed to any kind of a speedy movement. It just went completely still. Okay. Now in 2023, the matter of the Surat Sessions, the Judicial Magistrate First Class, which is the what you can call the first point of lower judiciary in criminal law. क्रिमिनल जस्टिस सिस्टम में जो सबसे पहला पॉइंट होता है जुडिशरी का, उसे कहते हैं जुडिशियल मजिस्ट्रेट फर्स्ट क्लास. उसके सामने क्रिमिनल डेफेमेशन का केस हुआ था, लेकिन उस पर कुछ कार्रवाई खास विशेष तौर से नहीं हो रही थी. अब 2023 में क्या होता है कि ये वाला जो मैटर है ये सामने आ जाता है दोबारा से, और सूरत का ये जो जुडिशियल मजिस्ट्रेट फर्स्ट क्लास है वो इस MP के इस बयान को सेक्शन 499 और सेक्शन 500 के वायलेशन में मैक्सिमम जो इम्प्रिजनमेंट था वो अवॉर्ड कर देता है. तो द इम्प्रिजनमेंट ऑफ 2 years, which is the maximum imprisonment, is awarded to this particular person, the MP, for using defamatory what you can say derogatory statements against a community or a group of people. ठीक है, and he is imprisoned, मतलब first of all he is convicted and then he is sentenced for the maximum punishment of 2 years minus a fine. बस फाइन ही नहीं लिया. तो जो ये जो दूसरा पनिशमेंट है ना इसमें, मतलब द ग्रेविटी ऑफ द एक्ट वाज कंसिडर्ड टू बी सो ह्यूज दैट द पनिशमेंट विच वाज गिवन वाज मैक्सिमम पनिशमेंट ऑफ 2 years, nothing less than that. Okay, that's here. Now, so this kind of a part is clear to you. Now we go back to what is the point that we were dealing with in terms of a disqualification. जो ये है 102 में जो क्लॉज 1 है, उसका जो सब क्लॉज ई है वो बोलता है कि अगर कोई व्यक्ति सेक्शन 8 रिप्रेजेंटेशन ऑफ पीपल्स एक्ट के अंदर डिस्क्वालीफाई हो जाता है तो उसको डिस्क्वालीफाई, मतलब अगर कोई व्यक्ति सेक्शन 8 के अंदर की कंडीशन पूरी करता है तो उसको डिस्क्वालीफाइड माना जाएगा. ठीक है. सो नाउ आई विल शो यू द नेक्स्ट एक्ट विच इज रेलेवेंट इन द मैटर, विच इज रिप्रेजेंटेशन ऑफ पीपल्स एक्ट इन 1951. ठीक है. अब इस एक्ट को मैं आपके सामने खोल के प्रस्तुत करना चाहता हूँ. इस एक्ट में जो हमारी रेलेवेंट आर्टिकल है वो सेक्शन है, वो है सेक्शन 8. Okay, we are back. Sorry for the glitch here. The server was acting up a little bit. Okay, so this is what I'm in a way referring to. We are talking about section 8 of the Representation of People's Act. Okay, so just let me redraw the whole story for you again from the start. There is Article 101 which talks about vacation of seats by an MP? Under what conditions can a seat be vacated? Now there are several grounds for vacation of seat, and one of them is by disqualification, that he can be disqualified. Then this ground of disqualification is further elaborated under Article 102, and then it has certain grounds which are given in the Constitution directly. For example, office of profit, for example, unsoundness of mind, undischarged solvent, and a citizen who's not in India, or a person who's not a citizen of India. Fifth ground which is given is Representation of People's Act 1951. Right, and the sixth ground, as pointed out by one of our friends over here, is anti-defection law under the 10th schedule. Okay, so I am taking the program from here, Representative People Act, and elaborating section 8. And within section 8 also, what I have to read is section 8 subsection 3. Okay, and this is what I say. Section 8 of the Representation of People's Act, which you have to very clearly give a very good amount of weightage and gravity to, says that disqualification on conviction for certain offences. A person, or what you can call an MP, can be disqualified on conviction for certain offences. Okay. Disqualification on conviction of certain offences is basically the point which has been given to the what you can call disqualification conviction of certain offences. A member of parliament can be disqualified from the parliament if he is convicted for certain offences. Okay. Now take a look at this. Section 8, subsection 8 talks about all the offences. Whenever we talk about the conversation about the criminalization of politics, for example, if we are asking the question as to why is there a rising number of people in the parliament or in state legislative assemblies who have criminal backgrounds. So the power which has been given to the parliament under the constitution is to create the Representation of People Act 1951, and within that notify what are the laws which if you break, you will not be allowed to contest elections, or if you have contested elections and have won and taken over the party or taken over the political leadership, then you will not be allowed to what you can call retain the seat of the member of parliament. Okay, let's say for example, one of the laws which has been introduced in section 8. Now, section 8 is like a compendium in which all the laws, all the actions which are done by people which are breaking certain laws, let's say for example rape, murder, let's say loot, or outraging the modesty of a woman. If a person has been convicted and sentenced for any of these laws or any of these punishments or any of these criminal charges, he shall be disqualified from becoming a member of parliament. And that is what section 8 subsection A does. It takes out, for example, let's say if anyone who has been imprisoned under section 498A of the Indian Penal Code, which is offence of cruelty towards a woman by husband or relative or a husband, then a person who has been convicted and sentenced for this particular thing will be disqualified as an MP. Similarly, for example, the Protection of Civil Rights Act 1955. This is an act which governs untouchability. Okay, if a person is found to be convicted and sentenced for untouchability, if a person is found to be let's say in commission of untouchability, he will be disqualified from being a MP. If he is a sitting MP, he will be thrown out, and if he is electing or he is fighting the elections for becoming an MP, he will have to make sure that he will not be able to qualify for the elections of the member of parliament. Okay, that's the point which has been given over here. Now, in pursuit to that, what you basically mean to understand is that these are the sections of different laws. For example, the Commission of Sati Prevention Act, the Prevention of Corruption Act, the Prevention of Terrorism Act. If a person has been charged and he has been convicted in any of these, he will lose his seat. But you don't have to remember all these offences. Just get a sense of what section 8 of the Representation of People's Act talks about. What you have to remember is section 8 subsection 3 of the Representation of People's Act. Now please, I invite you to read this part of the Constitution, of the Representation of People's Act, Section 8, subsection 3 of the Representation of the People's Act. It says that a person convicted of any offence and sentenced to imprisonment for not less than 2 years, other than any offence referred to in subsection 1, shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. This is a point that I am trying to make emphatically again. Then let's say, for example, the case that we are dealing with currently is that there is a case of defamation, which under section 499 of the Indian Penal Code and 500 of the Indian Penal Code gives a maximum punishment of 2 years imprisonment, okay, and which has been given to the member of parliament in concern. Okay. Now what we see alongside that is that there is a section in the Representation of People's Act 1951, section 8 subsection 3, which says that if any person has been convicted of an offence in which the punishment, the imprisonment is of 2 years or more, that person is going to be what you can call disqualified from being a member of parliament. Right? Now you can maybe join the dots and complete this entire storyline. An FIR is registered against the member of parliament. The FIR is heard by a judicial magistrate first class, and the result of the FIR, the hearing, is that the person has been convicted for 2 years of imprisonment, the maximum punishment which can be granted under the law. In further, the Representation of People's Act, section 8 subsection 3, which lists out the ground for disqualification as one of the grounds, which says that if a person is not, let's say, if a person is convicted or is imprisoned for a period of 2 years or more, then by that condition being fulfilled, he will be disqualified from being a member of parliament. Do you understand this? And that is basically how these two laws, section 499 and section 500 of IPC and section 8 subsection 3 of the Representation of People's Act, come together into effectuating the disqualification of the member of parliament from the Wayanad constituency in Kerala. Right? That's the point that we have to, in a way, keep in notice. Right? So you have, for example, the coming together of section 499 and a section 500 of the Indian Penal Code plus section 8 subsection 3 of the Representation of People's Act. Okay, and section 8 subsection 3 is driven by article 102 clause 1 clause E, which are grounds for disqualification made by parliament under the Representation of People's Act. Right. So on one end, as soon as the Surat magistrate, the judicial magistrate first class, gives a 2-year imprisonment under the punishment of section 499 of the IPC, on the other end, the Lok Sabha Secretariat notifies the operation of section 8 subsection 3 and disqualifies the member of parliament from the house. Right? This is a circumstance which has led to the effectuation of this particular situation. Okay. So I feel that this has become somewhat clear to you. Now in the next course of action, what the member of parliament does is, the member of parliament takes an appeal of the judgment of the JMFC, the judicial magistrate first class. The judgment of the judicial magistrate first class is taken by the member of parliament to the sessions court. In the form of an appeal. Appeal to suspend the conviction. and the Sessions Court of the Surat district has also agreed to the appeal made by the Member of Parliament and has agreed to suspend the conviction. The order of suspension of conviction will be released on 20th April 2023. Okay. The order of suspension of conviction has been granted by the Sessions Court, in which the Member of Parliament who was sentenced and convicted by the Judicial Magistrate First Class has been now released in a way. He has been declared to be not guilty under the defamation or whatever you is saying, and in a way it has reversed the order of the Judicial Magistrate First Class, but the details of the reversal of the order will be released to the public on 20th April 2023. Okay, so we have covered, for example, in the case of polity, 3 parts. One is Article 101, one is Article 102, Article 101 vacation, Article 102 disqualification, and within Article 102 you have Section 8, subsection 3 of the Representation of Peoples Act. Along with that, we have covered Section 499 and Section 500 of the IPC. This is an entire structure that you can memorize, reading directly from the Constitution and the Indian Penal Code. Any question which is coming from this can be answered directly by this kind of a reading. In further understanding, we talk about Article 103 of the Constitution in continuation with Article 102. Okay. Now, Article 103 of the Constitution states that if any question arises, okay, Article 103 of the Constitution states that if any question arises with regard to the disqualification of an MP under Article 102, if any MP is disqualified by the operation of Article 102 of the Constitution, then the Member of Parliament, if any Member of Parliament is disqualified by the operation of Article 103 of the Constitution, then the question which is arising out of that disqualification or about that disqualification shall be referred directly to the President of India. Okay, and the decision that the President will make in this regard shall be final. But there is one more proviso to that. The President, while he is making the decision, will refer the matter to the Election Commission, who will give the opinion to the President, and this opinion of the Election Commission shall be binding upon the President. Okay. So, I am getting a bit of a point across over here. What it means to say is that the government, which is the Lok Sabha Secretariat, which has given the order of notification of the suspension, the disqualification of the MP, if this order has to be raised as a question, if the MP wants to raise an appeal or a kind of a objection to this order, the authority for raising that objection is going to be the President of India, okay, under Article 103 of the Constitution, and the President, whatever decision he makes about the disqualification, whether it is correct or incorrect, agreeing with it or disagreeing with it, will then be making the final decision upon the matter. There is no other authority which can make a decision on the matter except the President of India. But the decision of the President of India can be taken only with consultation of the Election Commission of India. The President of India must seek the opinion of the Election Commission of India, and the President of India must be bound by the opinion of the Election Commission of India. So, in all said and terms category, if a question comes like this, that which of the following constitutional bodies has the final authority in terms of deciding a question with regard to disqualification of an MP? The answer would be President plus the Election Commission of India. Okay? President will take the final decision, but he would be bound by the opinion of the Election Commission of India. Okay? Do we understand this? Right? So, this is what we are talking about in terms of what is going to be the constitutional provisions that you have to understand with reference to the terms that we are taking a look at in Article 101, vacation of seats, Article 102, the what you can call Article 101, vacation of seats, Article 102, disqualification of member of parliaments, and Article 103 is what we call the powers of the President to refer the last questions for his disposal with the opinion of the Election Commission of India. These are articles that you can take a look at in tune with all of this. Just adding the last bite to this entire thing so that our current affairs upon this matter are full, square and complete. Take a look at this. Section 8, subsection 4. Okay. Now this is where I want to introduce a judgment by the Supreme Court which has been in the news recently. This judgment is Lily Thomas versus Union of India, 2013. Lily Thomas versus Union of India, section 8, subsection 4. Now just briefly go through the articulation of section 8, subsection 4 of the Representation of People's Act. Section 8, subsection 4 of the Representation of People's Act stated that if any person who has been disqualified as an MP because he has been punished for a period of at least 2 years of imprisonment as mentioned under section 8, subsection 3, then if he files an appeal within 3 months of such sentence, if he files an appeal within 3 months of such sentence, he shall be liable to get his disqualification annulled by the way of him filing an appeal. कहने का अर्थ ये है कि अगर मान लीजिए कि मैं एक मेंबर ऑफ पार्लियामेंट हूँ और मेरे को सेक्शन 8 सबसेक्शन 3 की कंडीशन के तहत डिस्क्वालीफाई कर दिया गया क्योंकि जो मुझे इम्प्रिजनमेंट मिला है वो 2 साल का या 2 साल से अधिक है, लेकिन कम से कम 2 साल का अधिक चाहिए मुझे, ठीक है। अब मान के चलिए कि सेक्शन 8 सबसेक्शन 4 के अनुसार मैंने अगर उस इम्प्रिजनमेंट के विरोध में अगर अपील दायर कर दी है किसी भी कोर्ट में 3 महीने के अंदर उस कन्विक्शन आने के, तो मेरे जो डिस्क्वालिफिकेशन है उसको कैंसिल कर दिया जाएगा, भले ही वो अपील डिसाइड हुई हो चाहे ना हुई हो, वेदर कोर्ट अहेड और हायर would have given me any kind of a relief or not. Regardless of that, just by the fact that I have drafted and filed an appeal in a higher authority will make me immune from getting disqualified from the parliament under section 8 subsection 3. This is what is meant in section 8 subsection 4. Please take a look at this section. पढ़िए एक बार इस section को. Right? It says that a disqualification shall not take place until 3 months have elapsed from the date. Okay, you understand the point? Now, this obviously section 8 subsection 4 of the Representation of People's Act is obviously a draconian kind of a thing. It's absolutely defeating of the spirit of the non-criminalization of politics. And what the Supreme Court received in 2013 was a PIL by a person called Lily Thomas, an advocate in the Kerala state. Lily Thomas filed a PIL with the Supreme Court asking the Supreme Court to declare section 8 subsection 4 as unconstitutional. And in this very case, Lily Thomas versus Union of India, again remember the name of the case, it has been in news ever since the controversy about the MLA being disqualified is happening. In this particular news, the government, the Supreme Court has struck down the section 8 subsection 4 of the Representation of People's Act, calling it ultra vires, saying that the parliament does not have the competence or the authority to make a law like this. Okay, so in today's date, section 8 subsection 4 of the RPA stands invalidated, unconstitutional as declared by the Supreme Court. Now, one of the things that happened with regard to this entire development was in 2013, when the Supreme Court gave the judgment striking down this particular law, then the Manmohan Singh government wanted to, in a way, give this kind of a law a kind of a extension. there was a case about the case of Lalu Prasad Yadav in the fodder scam, in which he had filed an appeal, but he was not able to get out of the jail because of the section 8 subsection 3 of the RPA being declared unconstitutional. So the Manmohan Singh government had brought an ordinance to remedy the actions done by the Supreme Court. And what the MP from Wayanad had done was, he had taken the ordinance in the public domain in the media briefing, and he had torn the ordinance publicly and thrown it out, which was a kind of a very kind of a very spectacular kind of a thing that was part of that particular kind of politics, and it's coming up for the repetition now also. Now the point that is being made in the media a long time is that if the member of parliament from Wayanad had not tore up that notification ordinance, and if the government would have been able to place that ordinance, then today he would have been able to prevent his disqualification, because he would have been covered under the immunity provided under section 8 subsection 4. That is the reason this entire saga was coming in the news again and again, of the member of parliament tearing up the documents. And also maybe you must have heard about this kind of a thing, that if those ordinance would have been placed, he would not have probably lost the membership in the parliament. Okay, but currently, as we have seen, that the Surat court has given, Sessions Court has given some relief to the person, and therefore you can see some kind of a thing. But nonetheless, this court judgment is going to be taken to appeal by the government again to higher authorities, or by the petitioner against to higher authorities, and the appeal, etc., will be moved around on that. So this is going to move from one court to another in a matter of appeal, until there's a kind of a political settlement of the issue, which is the main condition of the dispute. Okay. Right, let me take up the questions from here. Give us some glimpse about the office of Secretariat of Parliament. I'll take up some parts about the Lok Sabha and the Rajya Sabha Secretariat. Also with reference to the Lily Thomas case of the Union of India, we can take a look at the recent activities which are happening with regard to the Lok Sabha Secretariat, which is in the news. Okay, do section 8 apply for MLA? Yes, MPs and MLAs alike. Is there judicial review for President's order? Yes, there's a judgment by the Supreme Court in which it has said that the judiciary can review the President's order, but nonetheless the Constitution says that the President's order shall be final. So judiciary does not have a lot of room, but nonetheless in extreme cases of incongruency, judiciary can interfere in the matter and pass a review upon this. Samiksha Devi Singh, so which means that President's decision pending in case of the recent disqualification of the MP? No. Interestingly, the recent MP of disqualification has not filed a question before the President as of yet. He has not reached out to the President. But the reason that I'm teaching you this is that he may perhaps reach out to the President. And if he doesn't reach out to the President, UPSC certainly will maybe want to ask a question in this regard. Okay, a disqualified member can become a member of Rajya Sabha? No, he cannot become a member of Rajya Sabha. A member of Parliament who is disqualified for any of these things become eligible for any kind of movement into the Parliament, either with elections or with nominations. Okay, clear? Right, so here we have taken a look of complete clarity of the things which are happening in one of the most interesting cases which is developing in the current affairs. Okay, I'll repeat it again. What all you have to read directly from the Constitution to take a revision of this. Okay, first thing that you take is Article 101, vacation. 102, disqualification. 103, questions to be addressed to the President. Okay, and the President's address to be taken a look at by the Election Commission, whose opinion on the President's address shall be final. Okay. Take a look at Article 103 of the Constitution just for your own self. Article 103 says, a decision on questions as to disqualification of members. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in Clause 1 of Article 102, the question shall be referred for the decision of the President and his decision shall be final. This is Article 103, Clause 1. Okay? And Clause 2 of 103 says, before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. Okay? ठीक है? Clear. So this is one part that we have taken clearly a look at. Now the next current affair that I wanted to deal with, again a very interesting development of events in the polity paper, is the anti-defection law, right? Anti-defection law. Okay, so let me give you a brief sense of how to collect the literature upon it. Under Article 102, we have seen the grounds for disqualification. And one of the last grounds, in fact, the last ground for disqualification under Article 102, Clause 2 is what is known as anti-defection, or what is known as the 10th schedule. Okay, let's take a look at it in the Constitution. If you go to Article 102, Clause 2, you see that the 10th schedule of the Constitution has been mentioned under Article 102, Clause 2. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. Right? This we have taken a clear look at. Okay. Now, Sangamitra, disqualification rules are same for Council of Ministers too. Council of Ministers are necessarily supposed to be member of Parliament. Okay. And therefore, if you're not a member of Parliament, you cannot be a council minister. So what it entails is that a council minister cannot be disqualified as a council minister, but if she loses to be a member of Parliament, she cannot be a council minister. Right? So it, in a way, the answer to your question is yes. Okay? No precedent switch involved in that. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th schedule. This was not there in the original Constitution. This was added into the Constitution by the 52nd Constitution Amendment Act 1985. Please take a note of this. 10th schedule plus Article 102 Clause 2 plus Article 191 Clause 1 for the state legislatures. This was added in the Constitution by the 52nd Amendment Act 1985. Right? This was the Rajiv Gandhi government which had added the 10th schedule plus 102 Clause 2 plus 191 Clause 1 in the 10th schedule of the Constitution. Right? Now, the question that we are in a way, basing ourselves to understand is that what is the nature of anti-defection law, for which we'll have to take a reference to the 10th schedule. So this is the 9th schedule. Here, take a look at 10th schedule, and slowly and steadily we'll cover some important paragraphs of 10th schedule, and then I'll start developing a set of current affairs which are relevant in terms of understanding important recent developments about anti-defection. The case that I'll be dealing with is the Maharashtra government, MLAs moving from one political party to another political party, etc., etc. So this is what we can take a look at in terms of that. Right, take a look at this. Paragraph 2 of the 10th schedule says that disqualification of an MP on the grounds of defection. Okay, paragraph 2 of the 10th schedule lays out the grounds upon which a MP can be disqualified if he has committed a kind of a defection. Defection simply moves Ayaram Gayaram, which basically means that if a person is moving from one political party to another political party, this kind of a thing is known as defection. And in 1985, the movement of a person from one political party to another political party, which is going to be a kind of a movement of opportunism. Let's say, for example, if I am a person who becomes a member of parliament from one political party, let's say from BJP, but whilst I'm inside the parliament having won from the BJP ticket, I move my allegiance from one political party to another political party, then what I have done is defection. And under schedule 10 paragraph 2 paragraph 4, the movement of me from one political party to another political party is a event of defection, which is a ground or ground for disqualification. Okay. Just can we just take a break for just 5 minutes? There's a technical thing that may need addressing. 5 minutes. 5 minutes we resume again. Just got a message. Please wait for 5 minutes and we'll be back again. Okay, so here we are. We're taking a look at the disqualification on the ground of defection. Okay. Now, under the, let me just point it out properly. The 10th schedule is what is known as the anti-defection law. As we have seen that it has been added into the Constitution by the 52nd Constitution Amendment Act. Anti-defection law, the 10th schedule, right? Now, when we talk about the 10th schedule, what we see is it is divided into paragraphs. And we talk about paragraph 2. Paragraph 2 defines 2 conditions under which an MP can be disqualified if he has defected. 2 conditions which can be considered under the definition of defection. Okay, under the 10th schedule. Okay, 2 conditions. First condition is that if a member of parliament voluntarily gives up membership of the political party. If he voluntarily gives up a membership political party from which he entered the house. Okay. This is the first ground or condition for disqualifying someone of having committed defection. Second is, he may not voluntarily give up the membership, but he acts in contradiction to. The line, or let's say for example, the position of his political party. Position of his political party in voting behavior. These are the 2 grounds, only 2 grounds, which are considered to be what you can call the conditions under which defection can be ascertained, that a person has committed defection. Paragraph 2 of the 10th schedule. एक तो कि अगर कोई व्यक्ति अपना खुद का मेंबरशिप छोड़ देता है जानबूझकर, तो उसको डिफेक्शन के अंदर पार्लियामेंटेरियन के पोजीशन से डिस्क्वालीफाई कर दिया जाएगा. और दूसरा, वो वॉलंटरीली एक्सप्लिसिटली अपनी मेंबरशिप नहीं छोड़ता है, ठीक है, लेकिन वो वोट देता है इस तरह से कि अपनी पार्टी की जगह दूसरी पार्टी को फ़ायदा दिलाने के लिए वोट देता है। जैसे मान लीजिए कि अगर मैं भारतीय जनता पार्टी से मेंबर ऑफ पार्लियामेंट बन के आया और कांग्रेस ने मुझे बोला कि आप हमारे साथ आ जाइए, आपको जो भी मतलब पोजीशन है या जो भी पावर है वो दे देंगे। अब मैं बोलता हूँ कि मैं वॉलंटरीली मूव करूँगा तो मैं डिफेक्शन के अंदर लपेटा जाऊँगा। तो मैं क्या करता हूँ कि भारतीय जनता पार्टी के अंदर रह के मैं भारतीय जनता पार्टी जिन मुद्दों पे वोट देना चाहती है मैं उनको छोड़ के कांग्रेस जिन मुद्दों पे वोट देना चाहती है या जिस पोजीशन पे वोट देना चाहती है मैं उसके साथ खड़ा हो जाऊँगा। तो भले ही मैंने औपचारिक रूप से अपनी जो मेंबरशिप है वो चेंज नहीं करी है, लेकिन मेरे एक्शन से ये प्रतीत होता है कि मैं दूसरी पार्टी का जो है वो समर्थन ज़्यादा कर रहा हूँ अपनी पॉलिटिकल पार्टी से। तो अगर इस तरह का कोई बिहेवियर मेरे उसमें दिख गया एक्शंस में तो मुझे डिफेक्शन के अंदर डिस्क्वालीफाई कर दिया जाएगा। दिस इज गिवन अंडर पैराग्राफ 4. Yes, as Raksha is pointing out, against the whip of the political party. The whip of the political party in a what you can call parliament is, or any kind of a legislature, is basically a person who is supposed to be appointed by the political party, who is supposed to keep the entire political party in one group, and they have to vote for only one position. ऐसा नहीं हो सकता कि एमपी अलग अलग वोट करें सब लोगों को। तो अगर एमपी ने अलग अलग वोट करना शुरू किया, पॉलिटिकल पार्टी लाइन से उसके मतलब प्रतिकूल वोट नहीं किया, तो फिर जो आपका पॉलिटिकल पार्टी का जो विप है वो आपको एक तरह से वार्न कर सकता है कि हम आपको डिफेक्शन के अंदर डिस्क्वालीफाई करा सकते हैं। और अगर आप इस पॉलिटिकल पार्टी के विप की बात नहीं मानते हो तो इवेंचुअली आप डिस्क्वालिफिकेशन आप डिफेक्शन के अंदर डिस्क्वालीफाई हो सकते हो, क्योंकि आप देख सकते हैं कि ग्राउंड दूसरा यही है। अगर आप एक बार इसको पढ़ना चाहें तो पढ़ लीजिए। If you want to take a look at this, please take a look at this now. Disqualification on the ground of defection. Okay. If he votes or abstains from voting in such house contrary to the direction issued by the political party to which he belongs, then such person shall be liable to lose his seat on the basis of defection. अगर अपनी political party के contrary position पे वो वोट करता है तो उसको defection के अंदर लपेटा जा सकता है। ठीक है, चलिए, ये तो हो गया आपका पैराग्राफ 2 विच इज ग्राउंड्स फॉर डिफेक्शन। जल्दी जल्दी रिवाइज करना है इस चीज़ को। उसके बाद हम देखते हैं कि क्वेश्चन ये कि अगर इतने स्ट्रिक्ट ग्राउंड फॉर डिफेक्शन दे रखे हैं कॉन्स्टिट्यूशन के अंदर, इफ देयर आर वेरी क्लियर लेट्स से प्रोविजंस मेड टू स्टॉप डिफेक्शन विद इन द कॉन्स्टिट्यूशन ऑफ इंडिया, व्हाई इज इट दैट डिफेक्शंस हैपन सो ऑफ्टन? व्हाई इज इट दैट देयर इज सो मच ऑफ अ मूवमेंट of MLAs from one party to another party? Especially at the state legislative assembly, we hear this almost every month with some state legislative assembly that MLAs are moving from one particular political party to another political party, right? The answer to that question is the exemptions which are given with regard to the defection the answer to that is the exemptions which are given regarding defection in paragraph 4 and paragraph 5. So we'll take a look at paragraph 4 of 10th schedule. ठीक है, पैराग्राफ 4 में एक एक्सेप्शन दे रखा है कि कहां पर अगर कोई पॉलिटिकल पार्टी का एक व्यक्ति दूसरी पॉलिटिकल पार्टी में जाता है तो उसको हम डिफेक्शन नहीं मानेंगे, मतलब उसको डिफेक्शन के अंदर हम डिस्क्वालीफाई नहीं करेंगे। ये एक्सेप्शन है। और जो भी ये मूवमेंट होते हैं एमएलएस के एक पॉलिटिकल पार्टी से दूसरे पॉलिटिकल पार्टी की तरफ, वो इसी दौरान और इसी एक्सेप्शन के अंदर होते हैं। तो आप इसको समझिए ज़रा, मैं आपको समझाता हूँ इस चीज़ को बोर्ड पे। पैराग्राफ 4 में लिखा हुआ है कि मान के चलिए कि ये एक पॉलिटिकल पार्टी है, ठीक है। इस पॉलिटिकल पार्टी के मान के चलिए 60 मेंबर ऑफ पार्लियामेंट्स हैं या 60 एमएलए हैं सदन के अंदर, ठीक है। अब पैराग्राफ 4 में लिखा है कि अगर आप अगर आप 60 के अंदर में से 2/3, इफ यू कैन टेक 2/3 members of the legislative assembly from the political party and make those 2/3 members join another political party, ठीक है। जैसे मान लीजिए ये है पॉलिटिकल पार्टी नंबर 2 और ये है पॉलिटिकल पार्टी नंबर 1। अब इसमें क्या हुआ कि इस पॉलिटिकल पार्टी नंबर 1 के जो 60 एमएलए थे, इसमें से from 60 MLAs in this political party, 2/3 of MLAs from this political party move from PP1 to PP2. If it is at least a number of what you can call if it at least a number of what you say the political party moving from one political party to another political party, if it is at least 2/3 of the MLAs, then it will not be subject to defection. ये बात है कहने वाली जो हम कहना चाह रहे हैं, ठीक है. अगर एक पॉलिटिकल पार्टी से दूसरी पॉलिटिकल पार्टी में 2/3 लोग चले जाते हैं, 2/3 ऑफ द नंबर ऑफ इलेक्टेड रिप्रेजेंटेटिव्स इन अ हाउस, दोज रिप्रेजेंटेटिव्स ओनली, इलेक्टेड रिप्रेजेंटेटिव्स, अनइलेक्टेड रिप्रेजेंटेटिव्स का कोई दायित्व, कोई उनका अस्तित्व नहीं होता पॉलिटिकल पार्टी के सिस्टम में, ठीक है. तो अब अगर पॉलिटिकल पार्टी के 2/3 मेंबर यहां से वहां चले जाते हैं, तो उसका जो पैराग्राफ 4 में नाम दे रखा है उसे कहते हैं मर्जर. और मर्जर इज गिवन एज एन एक्सेप्शन अंडर पैराग्राफ 4 of the 10th schedule. So for example, if a question comes, what are the essential conditions for merger under the anti-defection law? You can see the essential condition for merger is a 2/3 of 60. A question can come, which of the following is a valid ground for exempting yourself from getting defected? Then you can give merger as the correct answer. Paragraph 4 talks about merger, and merger implies that 2/3 of the legislative assembly members move from political party 1 to political party 2. अगर 2/3 से कम है तो फिर वो डिफेक्शन का लॉ लगेगा, लेकिन अगर आपने 2/3 की संख्या टच कर ली है, उससे ऊपर जा रहे हैं, तो डिफेक्शन के लॉ से आप एग्जेम्प्ट हो सकते हैं. इसका अर्थ है कि जो हम देखते हैं कि एक पार्टी से जो दूसरी पार्टी में डिफेक्शन हो रहा है, और उसमें जहाँ पर भी आपको लगता है कि जैसे बिहार में होता है, कर्नाटक में होता है, गोवा में होता है, जहाँ पे एमएलएस कई महाराष्ट्र लेजिस्लेटिव असेंबली में, या फिर जैसे गोवा के लेजिस्लेटिव असेंबली में एक पॉलिटिकल पार्टी के 5 एमएलए हैं, तो 5 का 2/3 कितना होता है, उतने चले गए, 3 एमएलए चले गए, तो उससे भी बात बन जाती है, ठीक है. तो ये इस तरह से आप एक जो एंटी डिफेक्शन लॉ है उसको एक तरह से बाईपास करके पॉलिटिकल पार्टी के चेंजेस को कर सकते हैं. और इसी पॉलिटिकल पार्टी के चेंज के हिसाब से पीपल आर मूविंग फ्रॉम वन पॉलिटिकल पार्टी टू अनदर पॉलिटिकल पार्टी. क्लियर? दैट्स अ पॉइंट दैट आई वांट टू ले अ लिटिल बिट फोकस अपॉन, ठीक है. सो दिस इज व्हाट इज गिवन इन पैराग्राफ 4. उसके अलावा जो हम बात करते हैं वो है पैराग्राफ 5 की. पैराग्राफ 5 में एक और एक्सेप्शन दे रखा है. पैराग्राफ 5 में एक और एक्सेप्शन दे रखा है इसका डिफेक्शन का. पैराग्राफ 5 कहता है कि मान लीजिए अगर कोई स्पीकर है और स्पीकर के ऊपर आरोप लगता है पक्षपात करने का, इफ दिस एन एलिगेशन ऑफ अ स्पीकर और अ चेयरमैन ऑफ द राज्यसभा, द स्पीकर ऑफ द लोकसभा, इफ the speaker or the chairman of the Lok Sabha Rajya Sabha is under the allegation that he is being, let's say, in favor of the ruling party from which he is coming, that to prove himself as non-partisan, one of the methods by which he can prove himself as non-partisan is by resigning from the political party that he is a member of. एक statement होता है ना, once a speaker always a speaker. So one way in which he can prove his allegiance to non-partisanship is that he can resign from the political party in the duration of which he is a speaker. Now, paragraph 5 of the 10th schedule says that as long as a speaker is a speaker or holding the office of a speaker, and if he resigns from a political party, this resignation or voluntarily giving up the membership of political party does not amount to defection. He will not be disqualified from the house because of defection, provided that once the speaker is completed his duration, he joins back the same political party from which he entered into the house. एक बार स्पीकर अपना जो सत्र है वो खत्म कर लेता है, तो उसके बाद उसको उसी पॉलिटिकल पार्टी का हिस्सा बनना पड़ेगा जिससे वो निकल कर आया था, जिससे वो सदन के अंदर आया था. अगर वो किसी और पॉलिटिकल पार्टी का हिस्सा बन जाता है तो उसको डिस्क्वालीफाई किया जा सकता है. तो ये 2 एक्सेप्शंस हैं. अब आप बहुत सिंपल तरीके से इसको याद कर सकते हैं. आर्टिकल 102 क्लॉज 2 में 10th शेड्यूल का मेंशन किया गया है. 10th शेड्यूल में पैराग्राफ 2 है ग्राउंड्स ऑफ डिफेक्शन, 2 ग्राउंड्स हैं. पैराग्राफ 4 में एक्सेप्शन टू डिफेक्शन है. पहला एक्सेप्शन जो मर्जर का एक्सेप्शन था मैंने आपको बता दिया, 2/3 वाला, और उसके अलावा जो दूसरा एक्सेप्शन है वो है स्पीकर का एक्सेप्शन पैराग्राफ 5 में, ठीक है. इसके अन्यथा the next point about it we will take a look at paragraph 6 of the anti defection law. पैराग्राफ 6 ऑफ द एंटी डिफेक्शन लॉ सेज कि अगर मान लीजिए डिफेक्शन के रिलेशन में अगर कोई भी प्रश्न उठता है कि किसी का डिफेक्शन की जो प्रोसीडिंग्स है वो सही हुई है कि गलत हुई है, अगर डिफेक्शन के बेसिस पे किसी के ऊपर भी प्रश्न उठता है कि किसी व्यक्ति का डिफेक्शन सही है या गलत है, तो उस प्रश्न का जो फाइनल उत्तर है वो स्पीकर देगा और स्पीकर का डिसीजन फाइनल होगा. This is what paragraph 6 says, that any question which arises with regard to a matter of defection shall be referred to the speaker whose decision shall be final. But the Supreme Court has in what is known as the Nabam Rabia judgment. The Supreme Court has in the Nabam Rabia judgment held that the Supreme Court has in the Nabam Rabia judgment held that the powers of judicial review of the Supreme Court cannot be ruled out by paragraph 6. तो मतलब अगर स्पीकर का डिसीजन सही नहीं है तो सुप्रीम कोर्ट उसके अंदर जुडिशियल रिव्यू की पावर असर्टेन कर सकता है. ठीक है, ये नाबम रेबिया का जजमेंट है. आपके प्रीलिम्स के लेवल पे क्वेश्चन आ सकता है क्योंकि ये सारी चीज़ें न्यूज़पेपर में बार बार पाई जा रही हैं. एक बार आप पैराग्राफ 6 पढ़िए. पैराग्राफ 6 में यू विल गेट अ सेंस ऑफ व्हाट इज रिटन. और एनी क्वेश्चन अराइजेज एज टू वेदर अ मेंबर ऑफ अ हाउस हैज बीन कम सब्जेक्ट टू डिस्क्वालिफिकेशन अंडर दिस शेड्यूल, द क्वेश्चन शैल बी रेफर्ड फॉर द डिसीजन ऑफ द चेयरमैन और एज द केस में बी टू द स्पीकर ऑफ सच हाउस एंड हिज डिसीजन शैल बी फाइनल. ठीक है, ये प्रश्न है कि अगर किसी भी तरह किसी भी क्वेश्चन को मतलब अगर देखा जाए तो अगर किसी व्यक्ति का जो डिसीजन है डिस्क्वालिफिकेशन का अगर वो चैलेंज होता है तो उसका जो डिसीजन है वो स्पीकर ले सकता है. ठीक है, और इसी के साथ मैंने आपको बताया कि सुप्रीम कोर्ट का जजमेंट है नाबम रेबिया में जिसमें कि सुप्रीम कोर्ट में जुडिशियल रिव्यू एक्सरसाइज कर सकता है. तो ये क्वेश्चन आ सकता है आपके सामने कि क्या इसमें हो रहा है. तो मैं एक बार दोबारा से आपके सामने अलाइन कर देता हूँ चीज़ें. आर्टिकल 101 आर्टिकल 101 डिफेक्शन एंटी डिफेक्शन. आर्टिकल 102 क्लॉज 2 52nd कॉन्स्टिट्यूशन अमेंडमेंट एक्ट 1985 10th शेड्यूल. उसमें हमने देखा पैराग्राफ 2 है which is about the grounds for defection. ठीक है, उसके बाद पैराग्राफ 4 बात करता है. what does paragraph 4 talk about? The exemption of defection which is merger and the condition for merger is 2/3. और पैराग्राफ 5 बात करता है एग्जेम्पशन कि स्पीकर या चेयरमैन अपना त्यागपत्र, चेयरमैन तो त्यागपत्र नहीं दे सकता क्योंकि वाइस प्रेसिडेंट है, बट स्पीकर कैन गिव हिज रेजिग्नेशन फ्रॉम पॉलिटिकल पार्टी. And 6 is the power of the speaker or the chairman to take the final decision on the matters with regard to defection. ठीक है, this is something that we'll take a clear understanding of in terms of what is it. हाँ, तो the Holohan case है जो that is exactly also the same case in which the Supreme Court has said that the powers of the speaker under paragraph 6 of the anti-defection law are subject to judicial review. Power of the speaker cannot be a singular power which has no amount of review by the judiciary. तो यही बोला था इस वाले केस में. ठीक है, तो वो नबम रेबिया और दोनों का जजमेंट का जो रेशियो डिसिडेंडाई है, द एसेंस ऑफ दिस बोथ जजमेंट्स इज एग्जैक्टली द सेम. ठीक है, चलिए अब ये वाला हमारा एंटी डिफेक्शन का पूरा सिस्टम खत्म हो चुका है. तो हम अब एक जो करंट अफेयर है उसमें थोड़ा सा इसको ब्लेंड करके देख लेते हैं. ठीक है, जो करंट अफेयर हम कवर करेंगे यहाँ पर वो होगा शिवसेना की जो महाराष्ट्र में सरकार बनी है उसके ऊपर आधारित. ठीक है, तो आप थोड़ा ध्यान के दीजिएगा. इससे 2-3 चीज़ें जो हम समझ के कवर कर सकते हैं. क्वेश्चन आ सकता है इससे प्रीलिम्स में किसी तरीके का, क्योंकि इसमें एंटी डिफेक्शन के कुछ प्रोविजंस लगे थे और सुप्रीम कोर्ट के पास मैटर गया था. तो इट इज़ मतलब रीजनेबल दैट वी कैन कवर इट इन सम सेंसेस. ओके, यहाँ पर ज़रा देखिए, इन चीज़ों को हम लगा के थोड़ा सा वी कैन टेक अ लुक एट व्हाट इज़ बेसिकली हैपनिंग विद द रेलेवेंस ऑफ द एंटी डिफेक्शन लॉ इन डिफरेंट क्वार्टर्स। जो आप ये सामने देख रहे हैं 2019 के महाराष्ट्र जो लेजिस्लेटिव असेंबली उसके चुनाव के रिजल्ट्स हैं, ठीक है। तो यहाँ पर देखिए कि भारतीय जनता पार्टी को 2019 में 105 सीटें मिली, शिवसेना को 56, नेशनलिस्ट कांग्रेस पार्टी एनसीपी जो शरद पवार की पार्टी उसको 54, and the Indian National Congress got 44 seats, 105, 156, 54 and 44. And then there is independent party candidates who got 13, and you have other parties which got some singular seats, etc., etc. Okay. Now the question is this: the majority needed to make the government in Maharashtra is, I'm not sure about the exact number, but it is something about 145. कि आपको 145 सीट्स चाहिए. There are 145 seats that we need for forming the government in Maharashtra, but no one single party has a clear majority of forming the government in Maharashtra. Okay. Now, the 2019 elections end up creating a coalition government between these three parties. Shiv Sena with the highest number of seats within the coalition, then followed by the Nationalist Congress Party, and then the Indian National Congress. These three parties come together to form a coalition government. And the Shiv Sena, Uddhav Thackeray, becomes the chief minister of the coalition government. I'm sure at this point of time I don't need to explain to you the what you can call the effects or the what you can call the exigencies of what is known as a coalition government, right? तो यहाँ पर इन लोगों ने कोalition गवर्नमेंट डिक्लेयर करी अपने साथ एक दूसरे के साथ, और इस कोalition गवर्नमेंट के आधार पर जो कि इस कोalition गवर्नमेंट के आधार पे they formed the government, मतलब they claimed the roots of the government. Now what happens is that in Maharashtra, in Shiv Sena, which has 56 MLAs, शिव सेना स्टार्ट्स डिवाइडिंग इनटू टू फैक्शंस. एक तरह से शिव सेना के दो टुकड़े होने लगे. वन वाज नोन एज द उद्धव ठाकरे फैक्शन, द अदर वाज नोन एज द फैक्शन ऑन द नेम ऑफ द करंट चीफ मिनिस्टर. एक तरह से शिवसेना के अंदर भिड़ंत होने लगी बाय kind of a division of political party lines started erupting within the Shiv Sena, right? Now, when this kind of a thing was happening, then it was noticed that about 40 MLAs from Shiv Sena, along with Eknath Shinde faction, had moved from Mumbai to Guwahati, and they had locked all these 40 MLAs in a resort in Guwahati. Okay? Now, this is basically that people were now speculating that the 40 MLAs from Shiv Sena are now going to form government with the BJP and withdraw their membership from the Shiv Sena. ठीक है. तो looking at this kind of a movement, जब शिव सेना को लगा कि उनके 40 MLA बस में बैठ के गुवाहाटी फ्लाइट लेके गुवाहाटी चलेगा, गुवाहाटी में एक रिजॉर्ट में बैठे हुए हैं, they got a very clear indication that the 40 MLAs are going to leave Shiv Sena. As soon as they started moving away from the center, which is Mumbai, the political leader of Shiv Sena in the Vidhan Sabha of Maharashtra, he invoked the powers of the speaker under paragraph 5. Under paragraph 6 of a 10th schedule, he wrote a letter to the speaker saying that they should be disqualified. Okay, so the 40 MLAs, including Eknath Shinde, were disqualified by the speaker. What was the ground of disqualification? Paragraph to voluntary गिविंग अप ऑफ मेंबरशिप, इस बेसिस से स्पीकर ने डिस्क्वालिफिकेशन का ग्राउंड दे दिया। ठीक, ध्यान से सुनिएगा इस चीज़ को, बहुत रोचक चीज़ है, आपको समझ में आ जाएगी एक बार, इससे प्रीलिम्स के क्वेश्चन बन जाएंगे आपके आराम से, क्योंकि इस ताने बाने में कॉन्स्टिट्यूशनल प्रोविजंस का यूज़ होता है और इस तरह से आप याद भी कर सकते हैं आसानी से। ठीक, तो अब क्या होता है, चालीस एमएलए जो है वो यहां से चल जाते हैं और स्पीकर उनको डिस्क्वालीफाई कर देता है, स्पीकर डिस्क्वालिफिकेशन के पेपर साइन कर देता है। नाउ व्हाट हैपेंस इज, नेक्स्ट स्टेप इज दैट एकनाथ शिंदे, who is the leader of the what is known as the rebel MLAs, he reaches out to the Supreme Court, और सुप्रीम कोर्ट को वो नाबम रेबिया जजमेंट के अंदर अपील करता है कि सुप्रीम कोर्ट स्पीकर के ऑर्डर पे स्टे लगा दे। Supreme Court should put a stay upon the order of the speaker. Okay, this is what the Eknath Shinde faction goes and says to the Supreme Court. जो Supreme Court उसने प्रश्न पूछता है कि आप डिस्क्वालिफिकेशन में क्यों नहीं आते, तो एकनाथ शिंदे बोलता है कि जो पैराग्राफ 4 है उसके अंदर जो एक्सेप्शन दे रखा है उसके अनुसार हमारे पास 2/3 ऑफ 56 हैं और हम इन 2/3 को लेके भारतीय जनता पार्टी का पार्ट बनना चाहते हैं, और अगर हम ऐसा करते हैं पैराग्राफ 4 के अंदर तो दिस विल नॉट अमाउंट टू डिस्क्वालिफिकेशन। राइट, दिस इज क्लियर टू यू? That if the government, if the paragraph 4 is read, 2/3, 40 out of 56 is certainly higher than 2/3. If they move from one political party to another political party, then under the provisions of merger, they cannot be disqualified from the position of the member of legislative assembly. Clear? So Supreme Court के पास जाके बोलता है कि please stay our disqualification because we are moving from one place to another under a provision of law, and we will not be subject to disqualification under 10th schedule, marking the exception under paragraph 4 of the 10th schedule. Okay? Supreme Court उनकी बात मान लेता है। Supreme Court बोलता है कि आप ठीक कह रहे हैं, आप अगर आपके पास 2/3 मेजॉरिटी है तो आप डिस्क्वालिफिकेशन में नहीं आएंगे, और सुप्रीम कोर्ट जो स्पीकर का जो वो होता है डिसीजंस उस पर स्टे लगा देता है और उनका डिस्क्वालिफिकेशन रद्द कर देता है। लेकिन उसके बाद सुप्रीम कोर्ट एक और चीज़ करता है, सुप्रीम कोर्ट उनको बोलता है, महाराष्ट्र लेजिस्लेटिव असेंबली के लोगों को, महाराष्ट्र के गवर्नर को वो एक तरह से ऑर्डर देता है कि अभी तुरंत की तुरंत प्लीज कंडक्ट अ फ्लोर टेस्ट। Floor test is a kind of a what you can call a no confidence motion. Okay, now let's say for example, if the floor test is to be conducted, he said that without wasting any time, as soon as possible, please conduct a floor test. Floor test का मतलब होता है, let's say in the government you have 56 from Shiv Sena, 54 from NCP, 44 from Indian National Congress, and let's say 105 from BJP. ये मान लीजिए this is the composition of your Maharashtra Legislative Assembly. Out of this, let's say if 56 members, out of 56, 40 are of the rebel faction, मतलब they don't want to stand the ground of the political party. But the curious thing is this, that if you read, for example, paragraph 2, it says that if a member of a political party votes contrary to any direction issued by the political party to which he belongs, then he can be suspended for disqualification. Okay? You get the point? So, in this sense, let's say for example, if all these people have gathered in front of the Maharashtra Legislative Assembly Speaker, and these are political parties, let's say if 40, अगर जैसे मान के चलिए कि इनसे पूछा जाए कि क्या आप उद्धव ठाकरे की सरकार को समर्थन देते हैं कि नहीं, 44 MLAs over here are asked the question, do you give the what you can call the support to the Uddhav Thackeray government? Okay, if that kind of a question is asked of these MLAs, they would say yes, we give support. Fine. So 44 MLAs recorded Indian National Congress. Then the 54 MLAs from the National Congress Party are asked the question, do you give the support to the Uddhav Thackeray government? And they say yes. ठीक है, तो you have these number of MLAs from the National Congress Party. ठीक है. Now, if the Shiv Sena is asked a question, do all of your 56 members vote in support of the Uddhav Thackeray government? Let's say if these 40 rebel MLAs says that we don't vote and only 16 are left in support of the government, then it is possible that the government will have a no confidence. Right? The government will not be able to demonstrate its confidence. The figure of 145 cannot be achieved and the government will possibly fall. But the trick over here is this, that if they don't agree with the party line, let's say if Uddhav Thackeray, being the leader of this political party, tells all of these 56 people that you cannot have independent decision making with regard to this, you will have to beat the party line. Okay? And if, let's say for example, Uddhav Thackeray doesn't beat the party, if the 40 MLAs don't vote according to the official position of the political party, then they are subject to disqualification. So it could be possible that these 40 MLAs don't show confidence with the Uddhav Thackeray government, but the moment the government collapses, the very next moment what will happen would be a disqualification application made to the speaker with regard to the disqualification of the 40 MLAs from the member of Legislative Assembly, which means that the Maharashtra government would be in a situation in which it can say that if we don't make a government, 40 MLAs from the member of Legislative Assemblies from the Vidhan Sabha will be suspended and you will have to conduct by elections on these 40 seats. Clear? Now, in the absence of 40 MLAs, it is impossible for the Bharatiya Janata Party to make a government, because if it is 105 plus 16 which are favor of Maharashtra, and you obviously know that the Congress and the NCP will not support the BJP, there will not be a clear majority in the house and eventually the house will also collapse. So, when in the absence of a kind of a majority coming into the house, no one can create a kind of a Gathbandhan or a Gathjod in terms of answering the questions about the house, then the majority collapses and the house will have to be forced for a re-election, which is something that the Maharashtra government can do by getting the 40 MLAs disqualified under the grounds mentioned in paragraph 2 of the 10th schedule. I hope you are able to see it clearly. Yes? Okay. So, the government is preparing itself for the floor test, etc., etc. But very curiously enough, Uddhav Thackeray, as the Chief Minister of Maharashtra, even before appearing for the floor test, he resigns from the position of the Chief Minister. Okay. He resigns from the position of the Chief Minister and he does not participate in the floor test. At this point of time, Eknath Shinde, who is the head of the rebel faction of the Shiv Sena, Eknath Shinde, who is the head of the rebel faction of the Shiv Sena, what he does is he takes this opportunity and rather than merging with the BJP, let's say for example, this is Shiv Sena. Okay. Now the leader of Shiv Sena is, let's say, Uddhav Thackeray. He is also the CM of Maharashtra. But he resigns from the position of the CM of Maharashtra. Okay. Now the rebel faction of Shiv Sena, which is composed of, let's say, Eknath Shinde, who is trying to take 40 MLAs from Shiv Sena and merge into the BJP. Now, instead of merging with the BJP, what he does is, he files an application with the Election Commission of India. He files an application with the Election Commission of India, and under the Election Commission order symbols rules made by the government giving powers to the Election Commission. In this particular set of rules, these are important for your prelims examination, right? 1968 Election Commission rules, as they are known as. Okay. In the 1968 Election Commission symbols order, the Election Commission has the power to decide in the matters of political dispute between political parties. जैसे मान के चलिए कि एक कोई political party है, उस political party में दो खेमे बन गए और दोनों खेमे political party की leadership के लिए लड़ाई कर रहे हैं. They are fighting or contesting with each other for the political leadership of the political party. ठीक. तो अब अगर मान लीजिए कि एक खेमा और दूसरा खेमे के बीच में डिसीजन हो रहा है कि पॉलिटिकल पार्टी का जो चुनाव चिन्ह है, द इलेक्शन सिंबल ऑफ द पॉलिटिकल पार्टी और द प्रॉपर्टी ऑफ द पॉलिटिकल पार्टी और द फंड्स ऑफ द पॉलिटिकल पार्टी, द रिसोर्स ऑफ द पॉलिटिकल पार्टी, वो किस व्यक्ति के पास जाएंगे, हु विल बी द लीडर ऑफ द पॉलिटिकल पार्टी. तो अगर पॉलिटिकल पार्टी आपस में समन्वय करके इस प्रॉब्लम को सॉल्व नहीं कर सकती है, तो ये चीज़ें दोनों पॉलिटिकल पार्टी लेके इलेक्शन कमीशन के पास चली जाती है. इलेक्शन कमीशन हैज़ अ पावर टू डिसाइड हु इज द ट्रू ऑथेंटिक लीडर ऑफ अ पॉलिटिकल पार्टी. Okay, and so the Eknath Shinde faction goes to the election commission and says that we are the real leaders of political party called Shiv Sena, and therefore the symbol of Shiv Sena, the bow and arrow, the properties of Shiv Sena, everything with regard to the leadership of Shiv Sena shall be given to us, not to Uddhav Thackeray. And the election commission asks them the reasons why they think that they are the leaders of Shiv Sena. So the Eknath Shinde faction of the political party says that we have 40 out of 56 MLAs in our support. 40 out of 56 MLAs are in our support, and 13 out of 18 MPs, both in the Lok Sabha and the Rajya Sabha, are standing in our support. So what Eknath Shinde faction does is, he brings all of these people in front of the election commission, and he says that 13 out of 18 MPs, both from the Rajya Sabha and Lok Sabha, are standing in our support, and 40 out of 56 MLAs are standing in our support. And this is where the election commission applies what is called a test of majority. Again, an important term for identifying a prelims question, a test of majority, by which it can identify the real leader of a political party. By the application of the test of majority, the election commission gives an order in favor of the Eknath Shinde faction, stating that the real political leadership of Shiv Sena shall go to the Eknath Shinde faction. It takes away the political leadership of Shiv Sena, the sign, the symbol, the electoral representation, etc. All of these it takes away from the Uddhav Thackeray faction and transfers it to the Eknath Shinde faction. Now what happens is that Eknath Shinde becomes the political leader of Shiv Sena. Now let's say, how does the House act? You have 56 members over here with Shiv Sena, right? Now you have 40 under the Eknath Shinde faction who own Shiv Sena, and you have 16 now who are not in line with the political party. Okay. So now what he does is 56 over here and 105 over here, both of them, at least 40 plus 105, they reach the magic number of 145 and they form the government. But also you would understand at this point of time, if these 16 MLAs don't beat the party line given by Eknath Shinde, now they can be subject to disqualification. Right? They can be subjected to disqualification. Clear? You see how it turns around completely. Earlier the 16 were trying to disqualify the 40, but now because of the intervention made by the election commission, the 40 are now in a position to disqualify the 60 under paragraph 2 of the 10th schedule, which says that if a person does not vote in line with the political party in a particular house, they can be subjected to disqualifications under anti-defection law. Clear? Now the government in Maharashtra has been formed between the BJP, which has 105 seats, and the Maharashtra Shiv Sena, which has 40 seats, and Eknath Shinde faction, which is in lead, and slowly some members of the 16 seats also start joining the Eknath Shinde faction, eventually leading the chief ministership of Maharashtra government to come to a point. Okay? Clear? Do we understand this? Right? So you can, in reference to this, for example, remember the role of the Election Commission, the role of the Supreme Court in disqualifying, staying the order of disqualification, the relevance of part 4 and paragraph 4 and paragraph 5 and paragraph 2 of the 10th schedule. Okay? This entire current affairs structure is a good way to understand the points which are basically coming out over here in terms of what is happening in the Maharashtra State Legislative Assembly. Okay? Okay? So now what you have to do is read Article 102 of the Constitution, read paragraph 2 of the 10th schedule directly from the Constitution, take up the bare act of the Constitution and read it directly from the Constitution. Then read paragraph 5 of the 10th schedule, read paragraph 6 of the 10th schedule, and combine together, read the documents that I will provide with regard to the Maharashtra Shiv Sena case, and you will have a good understanding of how anti-defection law, any kind of question on anti-defection is going to come on this, because this is what happens in every case in which there is a movement of MLAs from one party to another party. This is the formula, that you have to move at least 2/3 of MLAs and you have to merge them in your political party. Now, in this case, as the events turned around curiously, the Maharashtra Shiv Sena first wanted to merge into BJP, but it got a better opportunity to control its own political party once Uddhav Thackeray had himself resigned and sidelined away. Okay, and therefore it made not a government by merger but by coalition, which is a different thing altogether. Okay, I hope this is becoming properly understandable by you. So this is another part that I wanted to take in the current affairs. Good, we are moving steadily. Right. Now let me take the another part with this regard, which is the constitutional provisions with reference to current affairs. Article 105 of the Constitution. Article 105 of the Constitution deals with a concept which is known as parliamentary privileges. Okay, parliamentary privileges, Article 150 of the Constitution. Now, Article 105 can be divided into two specific clauses, and I am going to give you in a very detailed kind of format about how this is happening. Article 105 clause 1 says that in Parliament there shall be freedom of speech, which means that the parliamentarians should be allowed to say whatever they want in the Parliament without any fear of any sort. Okay. Now, basically, when we talk about the rights of freedom of speech, they are given to a normal citizen under Article 19, Clause 1, Clause A. Right? This is the point at which freedom of speech exists within the Constitution. Article 19, Clause 1, Clause A, Subclause A. This is where freedom of speech exists within the Constitution. But the freedom of speech that exists within the Constitution is also very heavily restricted by Article 19, Clause 2, which provides for reasonable restrictions on the freedom of speech and expression. In comparison to this freedom of speech and expression, in comparison to this freedom of speech and expression, which is given by the constitution to a normal citizen, the freedom of speech which has been given to member of parliaments is extraordinarily strong and less liable to be restricted when that member of parliament is exercising that freedom of speech within the parliament. It's a very important thing to understand. Okay. So Article 105 Clause 1 gives freedom of speech to the member of parliament, and it is not as heavily restricted as the freedom of speech and expression of a particular individual is restricted outside the parliament. Let's say, for example, if a person has said something, let's say the member of parliament from the Wayanad constituency who has been punished under the defamation case by the, what you can call, the Surat court. Okay. If he had said the things that he had said inside the parliament, then he would not have punished by, he could not have been punished by any law. I think this kind of a thing makes sense to you when I'm trying to say that. Right. So Article 105 Clause 1, with regard to freedom of speech, it shall exist in parliament subject to the provisions made of the constitution. But all said and done, you have a more amount of freedom of speech in parliament as compared to Article 19(1)(a). A parliamentarian is freer to say things that he wants, he likes in his mind in front of the entire parliament inside the session. Okay, that's number one. Then the number two is that an MP inside a parliament has two basic actions. First, he speaks inside the parliament, and second, he votes inside the parliament. A member of parliament has two basic actions. Number one, he speaks inside the parliament, and number two, he votes inside the parliament. And what Article 105 Clause 2 says is that with regard to anything said by a member of parliament and with regard to any vote given by the member of parliament, he shall not be, or the reasons for saying something or reason for casting a vote on a particular manner, it cannot be inquired by any court. Which basically means that no law which applies on a individual citizen of the country will apply on the power to speak and power to vote of a member of parliament when he is speaking or voting inside the parliament. Let me give you an example of Article 105 Clause 2. It states that, let's say for example, there is a bill being debated in the parliament. The bill being debated in the parliament is, let's say, dealing with nuclear technology. Okay. Now, one of the member of parliament goes to the parliament to vote upon that bill. And while he's voting upon that bill, he takes out a, what you can call, a religious scripture from his bag. And then he closes his eyes and he reads a religious scripture. And then according to what he's reading in the religious scripture, he casts his vote upon the bill, as if he's taking inspiration from a religious book as to what can be done about this thing. Someone from outside can say that this man is superstitious or irrational, okay? That he's doing a kind of a non-reasoned exercise in deciding as to what vote has to be given to a law which is inherently determined by science and technology. Right? So a question can be raised, what is the basis on which the vote has been made? But Article 105 Clause 2 says that if any person is making any vote in the parliament, the method that he is using to make that vote cannot be questioned by any court of law. So if a person, for example, does a kind of a Jyotishi Shastra before he votes upon a particular matter in the parliament, he cannot be complained against by any court. He cannot even be made fun of by any media channel, etc., etc. You see the point? This is what is the next set of privileges known as the parliamentary privileges. Article 105 Clause 1, freedom of speech. In Article 105 Clause 2, right to vote, and the way in which whatever decision a member of parliament takes in the parliament with regard to his party line structures, etc., etc., cannot be questioned upon because his information or his reasoning on that decision is superstitious or anything else. Okay, because the parliament is supposed to reflect the true nature of India as it is. Okay. This kind of a situation becomes what you understand as a relevance understanding of parliamentary privilege. Third kind of a parliamentary privileges which has been given to the member of parliament is that, this is one which you can have an MCQ out of, is that, let's say for example, if this is an MP and this MP is involved in some case in which, let's say, there is an act known as the Negotiable Instruments Act. In the Negotiable Instruments Act, there is a provision which says that if you submit a check and if the check bounces, then you will be liable for certain, what you can call compensation. You will have to pay certain compensation to the bank and to the party that you have given the check. Now let's say for example there is a member of parliament who has given a check to some person, but the check bounces. Okay, if the check bounces and the person who has taken the check in the bank, they go to a civil court and they say that this person's check has bounced, the civil court says that this person has to pay an amount of 50,000 as a compensation for causing trouble to these people, and if he does not pay this amount, he shall be arrested. Let's say the member of parliament does not pay this fine. Okay, he refuses from paying this fine. Now what the parliamentary privileges basically say is that if, let's say, this is the session of a parliament, let's say for example you have the budget session or the monsoon session starting on, let's say, 15th of June and going on till, let's say, 20th of July. Imagine. Okay? This is the monsoon session which is going on from this period to this period. Now what the parliamentary privileges say is that in the duration of this session, okay, 40 days before this session and 40 days after this session, okay, within the duration of this session, 40 days before this session and 40 days after this session, this member of parliament cannot be arrested. Okay, for any wrong which is civil in nature. If there is some kind of a civil complaint against this person, then this person cannot be arrested for the period of time as it is mentioned above, 40 days before the session, during the time of the session, and 40 days after the session, he cannot be arrested. Alright, makes clear? Okay. Now, this kind of immunity that a person enjoys in civil cases does not extend in criminal cases. If there is a warrant against a person in a criminal matter, then he can be arrested even during the duration of the house. But for civil matters, if there is a warrant of arrest, then he can skip that arrest the duration of the house. Not only in the duration of the house, he can also skip the arrest in the time when he is attending the meetings of a parliamentary committee. So when, for example, you read about parliamentary committees is of course composed of parliamentarians, right? Parliamentary committee is composed of parliamentarians. Now the parliamentary committee की मीटिंग है कोई, अगर उसके ड्यूरेशन के दौरान उसके 40 दिन पहले और उसके 40 दिन बाद the person cannot be arrested for a warrant for violating a civil law in the country of India. This is one of the aspects of what is known as the privileges which are given to the parliamentarians. So I'll count 3 privileges which can be transformed as a multiple choice question. First privilege is that he can speak anything in the parliament. He shall not be liable to defamation, restrictions under Article 19, Clause 2, etc., etc. He can overcome these restrictions. Number 2, he can vote about anything in the parliament according to whatever logic he suits fit. Okay, he can do a akkad bakkad Bombay and vote in front of the entire world, and no law can be applied against him. Okay, and third, he is immune from civil arrests for the period which is mentioned in this particular phase. If you understand these three things, the person who is being given a kind of a privilege of the parliament membership can actually realize them, right? Now, in continuation with this concept of parliamentary privilege, let me discuss a subsequent concept, which is breach of privilege motion. Breach of privilege motion. Now, basically what it says is that, let's say for example, I'll give an example of it. Let's say this is a member of parliament. Member of parliament has stood up in the parliament to speak something. Okay, let's say for example, this member of parliament is representing the transgender community in India, right? And he has been elected by a constituency which has gotten overwhelming support by people who stand for the transgender or LGBTQ rights. And let's say for example, she makes a speech in the parliament, but let's say for example, some person somewhere who's watching the speech on the Lok Sabha TV or the Rajya Sabha TV, he takes that speech and makes a spoof out of it, create memes out of it, or does some kind of a profanity with it, etc., and circulates it in the social media, making fun of a person. Okay. Now, the question of parliamentary privilege entails that there is nothing in this country that can stop a parliamentarian from speaking his mind in the parliament. It's the most radical form of freedom of speech and expression. Okay, and it's obviously due, because if you cannot have the debate about what you want to feel correctly about, etc., if you can't speak your heart out in the parliament, then where do you have discussions about the society or the social problems or the social issues? Now, let's say when the transgender person, she goes back home and looks at all the social media full of her videos which are circulating, which are making fun of her, spoofing her, etc. This can be constructed by the parliament as a breach of its privilege under Article 105. You see the point? If any person inside or outside parliament tries to do some actions by which a member of parliament is dissuading or is dissuaded from speaking out freely or voting freely, okay? Let's say if there's a media channel which is broadcasting the parliament debate and they're looking at the parliamentarians and they're telling the people कि आप देखिए अपने अनपढ़ नेताओं को, इनको कुछ भी नहीं आता, इनको न्यूक्लियर टेक्नोलॉजी के बारे में A to B नहीं आता और लोग बिल पे डिस्कशन कर रहे हैं. Try to mock them, try to in a way create a situation in which you feel, make them feel inferior. Those member of parliaments, because of this kind of a public consciousness, may feel discouraged to stand up and speak in the parliament next time. They will not feel the confidence to do it, and they will not be able to represent the people who have sent them inside the parliament, right? Which would be a problem with the constitutional spirit. And therefore, in this particular case, let's say for example, if I am the speaker of the parliament, of the Lok Sabha, and I see this video which is making fun of this person, what I can do as a power is, I can take cognizance of a breach of privilege motion. Okay, I can do, but the power that I have is that I can punish, or I can start the proceeding for punishing the person who is breaching my privilege, breaching the privilege of the member of parliamentarian in my house. Okay, so for example, let's say what I can do as speaker is, I can ask the person to file a written complaint with me, and I can set a breach of privilege motion into order. A breach of privilege motion is a motion in which an investigation or an inquiry can be conducted. And if the investigation and inquiry is conducted by the parliament, and it is found that the person who has made the video is in breach of parliamentary privileges, he can be arrested. he can be arrested is number one as an option. The second, he can be reprimanded. For example, let's say if he's a journalist or something, his license can be cancelled. If it is a media house, its license can be cancelled. Okay? Or he can be made to publicly apologize to the parliament. Or he can be warned and let go of with saying that this should not repeat again. So this is one of the few instances in which the Parliament of India has powers of the judiciary. There are certain judicial powers which are given to the Parliament under Article 105 of the Constitution, which means that Parliament can act as a judge over matters which it considers are a breach of its privilege. Okay? So, one way in which a breach of privilege motion can work is that, let's say for example, the speaker looks at some particular person's privilege being breached, the speaker can take up the matter and send it to the privilege committee. Now, both the Lok Sabha and the Rajya Sabha have something called a privilege committee. I'm sure you've read about the parliamentary committees by now, and one of the departmentally related standing committee in the Lok Sabha and one in the Rajya Sabha is a privilege committee. The Lok Sabha privilege committee has 15 members and the Rajya Sabha privilege committee has 10 members. And the speaker, upon taking a cognizance of an action in which parliamentary privilege has been breached, can refer that application to the privileges committee of that particular house. The speaker to the Lok Sabha privilege committee and the chairman to the Rajya Sabha privilege committee. And the privilege committee can investigate into these actions and then subscribe punishment and keep the report about its investigations in front of the house. And the house can pass a motion by simple majority, and by that passing of the motion, the house has the power to punish the person who has breached the privilege of the member of parliament to speak or utilize their privileges under Article 105 of the Constitution. Okay? And it can also lead to arresting the person. You understand the point? So what is one of the basic impacts of the breach of privilege motion is that Parliament all of a sudden becomes a judge of a matter of its own accord. Okay? And Parliament has been given very clear judicial powers, and judiciary cannot interfere with the parliamentary powers. Okay? For example, let's say the procedure which has to be adopted by the parliamentary committee or the parliament to investigate into the crimes or the what you can call the act of punishing a person shall not be investigated into by the courts. Article 122 of the Constitution of India. This is something that you can understand and read carefully. Article 122 of the Constitution of India states that courts not to inquire into proceedings of Parliament. The validity of any proceeding in the Parliament shall not be called in question on the ground of any alleged irregularity of procedure. Let's say for example, while the parliamentary committee or the parliament itself is investigating the actions of a person who is blamed for breaching the privileges of the parliament, and if the evidence against that person has not been taken according to the principles set down by the Supreme Court to collect evidence, the court cannot interfere in the decision-making process of the parliament by saying that the procedure that you have followed to come to this conclusion is incomplete or invalid or unscientific. That is given under Article 122 of the Constitution. Please read it and try to learn it right now. You can have a very clear question coming out of it under Article 122, which is regarding the powers of the court not to inquire into the proceedings of the parliament. Okay? The validity of any proceedings in the parliament, मतलब कोर्ट पार्लियामेंट से ये नहीं कह सकता है कि तुमने जिस तरह से इन्वेस्टिगेशन करी है वो हम जिस तरह से इन्वेस्टिगेशन करते हैं उससे बहुत ढीली है, साइंटिफिक कम है, उसमें प्रिकॉशंस कम लिए गए हैं, उसमें आपने एविडेंस को जल्दी से आकलन नहीं किया, इसलिए हमको तो हम इन्वेस्टिगेशन करेंगे, या क्योंकि आपका जो इन्वेस्टिगेशन है वो स्टैंडर्ड से सेट नहीं है इसलिए आपकी इन्वेस्टिगेशन को हम रद्द करार कर देते हैं. ऐसी कोई भी पावर सुप्रीम कोर्ट के पास नहीं है. Eventually, if the parliament is not able to conduct inquiry completely scientifically, but the parliament feels that this person has done wrong, it can still punish that person, and the court cannot interfere in the decision of the parliament saying that the procedure that you have followed is incomplete or irregular. Article 122 of the Constitution. Achal, absolutely correct. Article 122 is the same as procedure established by law. If the parliament has established a procedure for investigation of any kind of a fault against itself, it is something that the courts cannot interfere in. Yeah, you're correct. So India's following procedure established by law in terms of India's following due process of law in terms of acts made by the parliament which is applicable on the citizens of India. But with regard to the internal regulation of parliament, there is no due process of law. Courts cannot dare touch the procedure of a parliament or the way that the parliament comes to a particular answering of a question. As we have seen, for example, if a member of parliament votes upon a particular matter reading a religious text, the court cannot interfere in that procedure. Neither can the court interfere in the procedure by which the committee is investigating evidences for coming to conclusions on certain matters. Neither can court interfere into the procedures which are taken by the parliament while discerning whether a breach of privilege motion applies to a particular person or not. You're absolutely correct. We are not moving towards a due process of law in the procedure established by the parliament for its own regulation, but by parliament to the regulation of the country as at large. But within the parliament is a sacrosanct. It does not have any obligation to listen to any person telling it that this process is unfair, unreasonable, unjust. You please rectify it. The parliament is not bound to listen to anyone. Yeah, that's obviously an example, as Shubhi is pointing out very clearly, of separation of powers, right? So I'm just referring to Article 105 of the Constitution over here. Okay, now let me just add a current affair event to the point which is being mentioned right at this stage. Okay. Recently in the Rajya Sabha,